The Kentucky Court of Appeals vacated a Louisville family court's decision, stating they violated dad's statutory right to cross examine the friend of the court. Let's break it down. Mom and dad get married in 2003, file for divorce in 2012. Yes, almost 13 years ago. They have a very acrimonious family court battle for a decade. They agree to joint custody with mom as the primary residential custodian. 2019, dad gets expanded parenting time. This upsets mom. Mom files a motion to reduce it. And of course, the court appoints a third party. So we now have a custodial evaluation that is to be conducted. Both doctors create an oral settlement conference. I wonder how much that costs. After the evaluation, dad's parenting time is restricted to 4 nights a month, and mom has essentially sole custody. Also, dad is ordered to attend therapy with Dr. Hammond. After a year and a half of this therapy, dad moves for more parenting time. So, what does the court do? Well, of course, appoint another third party. So, we have a friend of the court appointed in January of 2022, a decade after the divorce is filed. All right, so the parties agree on some things, but they get a hearing date about the expansion of parenting time and this custody issue. Dad asked to depose this third party that he is ordered to attend counseling with. The counselor says this deposition is not in the kid's best interest. Mom says this deposition is not in the kid's best interest. Dad lets the issue slide, and we have the friend of the court file a report. Now, the friend of the court is an investigative attorney appointed to represent the child's best interest. In this FOC report, the Dr. Hammond that was giving therapy to the children and dad is mentioned as someone the FOC spoke to about their recommendations. Dad requested all of the underlying data and information utilized to create the FOC report, but did not receive that until the actual day of the hearing because the FOC sent to the wrong email address. At the hearing, Dad moved to exclude the FOC report because he did not have adequate time to prepare, and it included inadmissible hearsay from Dr. Hammond. Dad lost. The FOC report was allowed, and an appeal follows. Stay tuned for part two.